Hello everyone. This presentation deals with the relevancy of character evidence under sections 52 to 55. When the question is whether a person did or did not do a particular act, his character, which shows whether he is the kind of person likely to do it or not, should be taken into account. But the law in existence says no. The reason is the difficulty of knowing the real character of a person. Very often, every person has two reasons for most of his activities. The one which he announces to others, and the other, the real reason which he alone knows. If the secret reason can be known, then the real character of the person can be known. One can understand conduct, that is, how a man behaves, but one cannot guess the real character of a person, that is, why he behaves in a particular way. So, in law, the extent to which evidence of character can be given is limited. The law on this aspect is set out in sections 52 to 55. Section 52 and 55 deal with evidence of character of parties in civil cases, and section 53 and 54 deal with the evidence of character of parties in criminal cases or character of the accused in criminal cases. What is character? Section 55 has an explanation which explains what is meant by character. According to the explanation, the word character includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition and not of particular acts by which reputation or disposition were shown. Reputation of a person means the estimation in which the public holds him. This is not based upon personal knowledge of a person. Disposition of a person means his nature, and this can be spoken of by persons having personal knowledge. For example, a husband and wife have a reputation of being a loving couple, but a family friend may know the truth that in spite of their good behavior in his presence, there will be actions and statements which give the clue and show a way. According to section 52, character evidence is irrelevant unless such character evidence is itself an issue. In civil proceedings, the evidence of good character or bad character will not help the court in deciding the matters in issue. Evidence of good character is excluded from civil proceedings on the grounds of public policy because giving evidence of unconnected circumstances will prejudice the party and he does not get an opportunity to defend effectively because he does not know what part of his character would be attacked. But if it is in issue, it can be proved. For example, a Hindu widow of a member of a joint family under customary law sues the other members for maintenance, and the question is whether she has lost her right to maintenance because of her unchastity. Evidence of bad character can be given because it is relevant. Section 55 deals with the relevancy of character as affecting damages. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. In a suit for damages for defamation, evidence of the bad character of the plaintiff is relevant and such evidence can be given. This can be done to mitigate damages. Defamation means that a person is exposed to hatred, ridicule, and contempt as a result of the statement made by the defendant about the plaintiff. And since it is a matter of reputation, it can always be shown that he has no reputation to lose. According to section 53, in a criminal proceedings, the fact that the person accused is of good character is relevant. The innocence or criminality of an accused can be easily judged by looking at his character, and the accused must be allowed to prove his innocence with the help of his good character. Sometimes, when the evidence is against the accused, the good character of the accused may come to his rescue. If the accused is deprived of the opportunity of setting up his good character in his defense, that amounts to denial of fair trial. According to section 54, in a criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character in which case it would become relevant. The reason is that the prosecution must prove the guilt of the accused beyond reasonable doubt. It cannot be allowed to take the help of bad character of the accused to establish its case. If this is done, it would prejudice the mind of the court and the court would be biased against the accused. However, there are three exceptions to this rule. The first exception is contained in section 54, which says that when the accused gives evidence of good character, the prosecution has a right to prove the bad character of the accused. The second exception, which is contained in explanation 1 to section 54, states that evidence of bad character can be proved in cases in which the bad character is itself a fact and issue. When security proceedings under sections 109 to 118 of the Criminal Procedure Code is to be taken against a person, the bad character of the person is in issue. In such proceedings, the bad character of such persons who are notorious criminals and antisocial elements is necessarily in issue. Evidence of bad character in such proceedings is admissible. The third exception contained in explanation 2 to section 54 says that a previous conviction is relevant as evidence of bad character. Such evidence of previous conviction would be relevant under section 75 Indian Penal Code in cases where the accused is liable for enhanced punishment, when the accused, having once been convicted of an offence punishable with imprisonment for a term of 3 years and above under chapter 12, which deals with offences relating to counterfeiting coins, or under chapter 17, which deals with offences against property, again commits an offence punishable with imprisonment for a term of 3 years and above under those chapters. There is one important difference between the Indian law and the English law in relation to character. Under Indian law, character means both general reputation and general disposition, whereas under English law, character means only general reputation. This is about character evidence as provided under sections 52 to 55 of the Indian Evidence Act. Thank you.